The second key element of the withdrawal agreement is the divorce bill, or more formally, the financial settlement. It was unclear for some time what this would be, with quite wide variations in estimates from the negotiating sides, 30 billion to 60 billion euros. Here we might legitimately wonder, why isn't it obvious what the UK owes the EU? There is no definitive cost to the settlement. Rather, it's based on a set of principles agreed between the UK and the EU in the withdrawal agreement, which mean that the UK will be paying something to the EU for several decades. The overall estimated net cost by the UK's Office for Budget Responsibility is around £33 billion. The settlement is more than what the UK sent to Brussels in 2015 after deducting the rebate to which the UK has been entitled since 1984. In other words, the direct burden on British taxpayers. This prompts two questions. Why is it so much? And more provocatively, could the UK refuse to pay? And if it does, what might then happen? The bulk of the amount comes from commitments to the multi-annual financial framework, MFF, of the European Union budget, which sets amounts for annual European Union spending. The UK continued to pay into and receive from the EU budget until the end of 2020. The MFF 2014-2020 is embodied in a legally binding 2013 regulation, agreed as is customary by both the Member States acting through Council and the European Parliament. The regulation has a clause explaining what is supposed to happen if the EU enlarges while the MFF is in progress, and another about what should happen if Cyprus is reunified, but it makes no provision for a member state leaving. The second main component is for budgetary commitments already made by the EU up to the date of Brexit, but for which the payments will only be due later, known in Brussels speak as RAL, the French acronym for Reste à liquider, still to be settled. These arise for multi-annual economic development projects, predominantly in the less prosperous parts of the European Union. The UK will also be liable for its share of the pensions of European Union employees who retired while the UK was a member of the Union. The potential gross cost will be partly offset by subtracting flows of money the UK can expect to receive, for instance, the capital that the UK paid into the European Investment Bank. The UK would be formally in breach of the financial settlement reached in the withdrawal agreement if it refused to pay in the future, after the end of the transition period. Settlement of that dispute would take place under the dispute settlement provisions of the withdrawal agreement. These provide for an arbitration mechanism with a continued, though indirect, role for the Court of Justice of the European Union. In contrast to the usual jurisdiction of the Court of Justice of the European Union, there is no direct access to the dispute settlement for individuals here. The UK is clearly to be outside of the EU's new legal order, the subjects of which comprise not only member states but also their nationals, in the word of the Van Gent-on-Loos case, and which is endowed with a complete system of legal remedies, according to the Court of Justice in Opinion 1/2009 on the Unified Patent Court. Disputes under the withdrawal agreement must first be attempted to be settled by diplomatic means, under Article 169 of the withdrawal agreement, using the Joint Committee. Failing that, either the UK or the EU may request that an arbitration panel of 5 people is established under Article 170 of the withdrawal agreement. The arbitration panels are to be staffed from a list of 25 persons established by the Joint Committee. 10 of these are to be proposed by the EU, 10 by the UK, while both together propose 5 persons as possible panel chairs under Article 171 withdrawal agreement. While as a matter of principle the arbitration panel should operate on the basis of consensus, if a decision is impossible to reach in this way, the panel shall decide by a majority vote, Article 180 withdrawal agreement. No dissenting opinions are published. Panel rulings are binding under international law on the UK and the EU, Article 180 of the withdrawal agreement. This looks like a standard dispute settlement procedure found in ordinary trade agreements. It's nothing like dispute settlement in ordinary EU law. But there is a small indirect role for the Court of Justice of the European Union. If a dispute involves a question of interpretation of a concept of union law, a question of interpretation of a provision of union law referred to in this agreement, the panel must instead refer it to the European Court of Justice, requesting the Court of Justice to give a ruling on the question under Article 174 of the Withdrawal Agreement. The Court of Justice's ruling is binding on the arbitration panel. If the party against which the arbitration panel finds refuses to comply with the panel's decision, then ultimately, after various other procedural steps have taken place, the complaining party, so here if the UK was in breach of its obligations under the financial settlement, the EU, can suspend its obligations under the Withdrawal Agreement. But the suspension of obligations may not include suspending obligations under the citizens' rights part of the Withdrawal Agreement, and that rule is found in Article 178(2)(1)(a) of the Withdrawal Agreement.